Despite the holiday weekend, closing arguments in the Casey Anthony murder trial are scheduled for tomorrow, Sunday, and the prosecution and defense are spending today preparing. The 25-year-old Florida mom charged with murdering her 2-year-old daughter, Kaylee. The defense says the toddler accidentally drowned. Let's bring in our legal panel to weigh in on this. Karen DeSoto is a criminal defense attorney and former prosecutor, and Keith Sullivan is a criminal defense attorney. Anna, good morning to both of you.
Good morning.
Okay, first up, this is all happening on a Sunday. How unusual is that, Karen?
That's really unusual.
Yeah.
But, you know, I have to say that judges are pretty good about going to the jury and saying, listen, I'm going to give you a couple options. Do you guys want to come in Sunday and then have Monday off? Or do you want to do Saturday? Or they'll ask, and then they'll say, no, Your Honor, we don't have a problem with that.
They just want to get it done.
Yeah.
But, Keith, I mean, how much concern do you have over 4th of July looming right there? You get something on a Sunday and anybody thinking, well, maybe let's just get through this, or you're not worried about this trial?
A lot of times jurors will rush a verdict through based upon the circumstances of their life and the calendar. And that's just the reality. I mean, here you have a sequestered jury. It's very important that you use the clock and use their time. So you have to bring them in on a Sunday and work.
All right, well, we'll get to all that more tomorrow. But let's look at what happened yesterday, Karen, because the state brought in this rebuttal witness, and this was an employer for Cindy Anthony, Casey's mom, who said basically, during Cindy Anthony's testimony, saying, you know, I was the one who searched for chloroform, did that on the computer. This guy's saying, yeah, actually, she was at work. I mean, what does that do to the testimony?
Well, it, you know, makes her look like a really good mom trying to lie for her daughter. But as far as the premeditation, it kind of puts that back on the table a little bit there. I mean, listen, is a juror ultimately going to say over a computer search the difference between premeditated murder and aggravated manslaughter? Probably not, but it's out there, and now you know that she lied, and therefore the credibility is, again, a problem.
And do you worry about Cindy Anthony facing perjury charges?
Well, I'm sure Keith can attest to this. I've had people lie on the stand with 3 different statements, lying about very serious things like rape and lying for their kids. Never charged with perjury. It's one of the biggest problems I have with the justice system, is that people can lie about raping and get on the stand and tell 3 different stories, and the prosecutor's office doesn't even touch them.
Okay, Keith, we look at the prosecutor's case. It's largely based on circumstantial evidence. I mean, there's been statements out there many times that we may never know exactly how little Kaylee Anthony died. So you've got these jurors here, these 12 jurors and the 5 alternates. These are just average citizens. How do they process this? How much do they personalize it as opposed to try and put on a professional juror's hat?
How they process it in this case is through the expert, Dr. Voss, who talked about the vapor component test in the air, the sniff test, if you will. And I think that, although maybe some of the strongest evidence for the prosecution, will be the most damaging and hurtful evidence for the prosecution on appeal. That evidence should have never come into that courtroom. And what's disturbing is that they didn't need it. 4 lay witnesses took the stand and said, I've smelled death, and that was death. The smell test doesn't pass the Fry standard, which is a U.S. Supreme Court test. Why Judge Perry let it in is mind-boggling, and it's difficult, and lawyers are struggling with trying to understand it.
So you think that could help, let's say, potentially convict Casey this time, but then on appeal, it's like, uh-oh.
That's her get-out-of-jail card. As soon as he testified, I said she should go into court every day and say, thank you, Judge, thank you, Judge, thank you, Judge, because she gets a redo. And statistically, retrials always favor the defense.
Okay. Karen, we got to get to the defense. What they did was started the trial alleging that Casey had been sexually abused by her father, and that little Kaylee was accidentally drowning in the pool, and the dad helped cover it up. Was that the best defense that Casey could have gotten under the circumstances?
Yeah, you know, he did a pretty good job at knocking out the premeditation. Thank God he didn't put her on the stand.
Yeah.
But really, you know, it was funny because I was talking to Keith about this. Even if she doesn't get the capital murder and she gets the aggravated manslaughter of a child, I think people have a hard time understanding that that's still a first-degree crime. Plus, if the judge, when he sentences her, can do it consecutively. So she could be doing just as much time as if she got the premeditated.
But that would take death penalty off the table.
You take the death penalty off the table. And clearly you saw Cindy testify during the trial. She's trying to spare her daughter's life. I mean, it's proven that Cindy lied on the stand. There's no question about that. But why did she do it? She's trying to take away the premeditation, and she's adopting what some consider the most damaging evidence that goes to prove premeditation, the search for chloroform.
Yeah, okay. All right, Keith, Karen, we're going to have you back a lot this morning. So much to talk about. DSK, this and the other. Okay, thank you. There are usually just 50 courtroom seats reserved for the public to see the Casey Anthony trial, but for tomorrow's closing arguments, you are going to get a front row seat. We're going to bring you live gavel-to-gavel coverage tomorrow on